Hi everyone. In this video, we are going to discuss about who an employee is and Employee Compensation Act. So, Employee Compensation Act was earlier known as Workman Compensation Act, and through an amendment, it was renamed as Employee Compensation Act. Section 2, Subclause 1, Subclause N of the Workman Compensation Act defined who a workman is. This section was omitted by the 2009 amendment, and Section 2, Clause 1, Clause DD was inserted, which defines who an employee is. So, to understand who an employee is, it can be categorized into two. That is one with respect to Railways Act of 1989, and the other one, Schedule 2 of Employee Compensation Act 1923. So Section 2, Subclause 34 of the Railways Act 1989 defines a railway servant. A railway servant who is not permanently employed in any administrative, subdivision or divisional office of a railway will come under employee. However, even if the railway servant is employed permanently in any administrative, divisional or subdivisional office of a railway, even in that case, if the person is employed in such a capacity as prescribed in Schedule 2 of the Employee Compensation Act, then that person will also come under the definition of employee. Now, Schedule 2 of the Employee Compensation Act 1923, there is a long list of or of duties or categories of people, or the people who works in the such capacity prescribed in Schedule 2, who will come under the definition of employee. So, for example, with respect to people working outside India, if any member of the crew of a ship, or a captain or crew of an aircraft, or a person such as driver, helper, or mechanical who is employed in a motor vehicle, or a person recruited by a company, all these people, if they are working outside India, and the respective ship or aircraft or motor vehicle or company is registered in India, then they fall under the category of employee, or they can be considered as an employee. And any person who is performing or employed in such capacity as prescribed in Schedule 2 will fall under the category of employee. However, there is one single exception to this, that is, the members of the armed force, irrespective of the capacity in which they are employed, the armed force of the union, members of armed force of the union will not fall under the category of employee. Towards some case laws, T.N. Sidarama Reddy versus A.I. Swami Gaunda. Here, the person wanted to deepen the already existing well in his plot, and he himself supplied the gunpowder for the diggers. While using the gunpowder, there was an explosion, and one of the digger lost his right arm, and he claimed for compensation, and it was allotted. It was here the commissioner decided that he is entitled for compensation because he falls under the category of employee as per section 2, clause 1, clause N. Now, Jeetala Manakji versus Sharma Sharadambal Ammal. Here, the hotel keeper wanted to renovate the hotel and the rooms from his own savings, and for this purpose, he employed a mastri, and the mastri in turn employed few bricklayers, and one of the bricklayer fell from a height, and that resulted in his death, and the widow claimed for a compensation. Here the compensation was given, and it was held that though the bricklayer was not directly employed by the mastri, he was doing the work for the hotel. I mean, directly employed by the hotel keeper. He was doing the work for the purpose and business of the hotel keeper, and thus he shall be brought under the definition of employee. Now, Gaunda versus Workmen Compensation Commissioner. Here, an agricultural engaged few band of diggers to dig well in the agricultural land, and here these diggers were brought under the definition of employee as they were performing the activity for the business and purpose of the agriculturalist. So they were brought under the definition of employee. Now, another case was Ganeshan versus Bhagwati Amma and Anda. Here, a person was entrusted with the duty to collect and credit the freight charges for goods transported. Here, there was no official agreement or no official employment, but it was an implied employment, and the commissioner the findings and the commissioner ruled that this person has to become brought under the definition of employee as per section 2 clause 1 clause n of the Workmen Compensation Act. Now, K. N. Narayan versus Divisional Superintendent, South Railway. So this is a case related to licensed porter who licensed porter is a railway servant by Section 3, Clause 7 of the Railways Act. He met with an accident during the course of his employment. That is, he was loading some of the goods to the train and a passenger accidentally pushed him down. He fell to the railway track and a train passed over him, causing him to lose his one of his legs, and he claimed for compensation. Initially, the commissioner rejected the claim, saying that there is no direct employment by the railway and the license porter, but there was so they preferred for an appeal, and the court said that the railway has control and supervision over the licensed porters. So there exists an employee-employer relationship, and this person has to be brought under the definition of Section 2, Clause 1, Clause N, and it shall be read along with Schedule 2 of the Employee Compensation Act. This porter is entitled for compensation. And then the another case is Dathamani and others versus Secretary Home Office. Here the deceased was a driver in police department for the state of Kerala, but he died in an accident during his employment, and the widow claimed for compensation, but this claim for compensation was denied, saying that he's a member of the armed force and he does not fall under the definition of Section 2 clause 1 clause n of the Workmen Compensation Act. There was an appeal preferred, and the court held that he has to be brought under the definition of workman under Section 2, Clause 1, Clause N, and it has to be read along with the Schedule 2 of the Employee Compensation Act. He performs his duties in such capacity as prescribed in Schedule 2, and thus he has to be considered as an employee. So the exception is only for members of armed force of the union. There is no other exception. So that is with the section who an employee is under Employee Compensation Act. I hope this helps. If you like the video, please click the like button, and if you are not subscribed yet, please do subscribe to my channel to support me. Thank you. Have a nice day.